Hi, I'm Matt Culkin, co-chair of Steptoe's Financial Services Group, and welcome to Steptoe's Financial Services University. We're pleased to present a series of short, focused conversations with my colleagues from across our firm's practice groups and offices around the world. Today we're going to talk about judgment enforcement in commercial disputes. I'm joined by my colleague Steve Davidson, a partner in our Washington office. Steve, thanks for joining me.
Thanks. Happy to be here. Hope I can be of some help.
So before we get into it, it's probably helpful for our audience if you just describe your background and your practice.
Sure. I'm what we call a Steptoe lifer here. I joined the firm in 1985 when I was 12 years old. And I've been practicing in commercial litigation ever since I joined Steptoe. And for the last 20, 25 years, I've really developed a concentration in judgment enforcement and asset seizure and execution. And I'm the co-head of our group here in commercial litigation, what we call complex commercial disputes. But what I really want to talk about today and engage with you all in is the part of my practice that deals with judgment enforcement.
So let's start with the basics. What is judgment enforcement and why is it so important?
Well, at the most basic level, it's always great when you win a case, but unfortunately, the only thing you get when you win a case is a piece of paper. And without being silly about it, what clients really care about is money, not pieces of paper when they're plaintiffs. And it's often a lot more difficult than people understand to turn that piece of paper into money. And what we specialize in is doing that. And we've done it for, as I said, for many years across the globe. And what makes it difficult is that when a well-financed defendant is eager to resist enforcement of the judgment, it isn't so easy necessarily to get them to pay. Unfortunately, from our perspective, we don't have debtors' prisons anymore. So there's only so much pressure that one can bring to bear on a recalcitrant judgment defendant. And that's where it really is a specialty. I've found that highly skilled litigators who are wonderfully able at getting the judgment and succeeding in the case, most of them have really very little understanding of how to turn that into money. Even the most basic elements, like how do you get a stay automatically? Do you get a stay pending appeal? If you have assets in other jurisdictions in either within the United States or overseas, how do you turn that into money? And some of it is really sexy, like we've attached and seized yachts on the high seas, airplanes, gotten boots on airplanes like the Denver boot, like you have on your car on the tarmac in airports around the world, high-priced condominiums. And some of it is a little more mundane, but just as perhaps more remunerative, which is, finding cash assets in bank accounts. And it's really requires a great deal of perseverance. It requires your client to be patient, which often is difficult to convince a client to be after they've gone through years of litigation to get to this end game. And now they have a piece of paper, but they don't have money. And one thing I would advise both clients and lawyers in dealing with cases on the plaintiff side is to make sure everyone understands what it's going to take to actually collect on the judgment. And that's important for a couple of reasons. One, you want to make sure your expectations are correct, because sometimes we've had clients that are referred to us from the lawyers who handle the underlying case, and they're honestly shocked that they're not getting paid when the case is over. So people have to understand that that's a potential outcome. Now, in most cases, that isn't the outcome. You have two sizable companies or reputable individuals who litigate against each other. And then when, maybe they'll post a bond to avoid execution on appeal, but when it's over, one side pays the other, or they enter into a settlement to take into account some discount for the appeal. But in the ones we deal with, that's not what happens. And people have to brace themselves for that possibility, which is important, not just for expectations, but so that as the case goes along, you've understood that there needs to be a strategy for how do we collect? How do we make this judgment enforceable, both in the United States and around the world? And there's a real sort of strategy to doing that.
And I'm curious, so you've mentioned the high seas, you've talked about around the world. Are there certain areas or jurisdictions where you find that you've had more activity than others?
Yeah, I mean, it's it's sort of like that old saying when there was a hearing in the 30s during a lot of crime, and someone asked one of these famous bank robbers, "Why do you rob banks?" And he said, "Well, that's where the money is." And so how these things turn out in terms of where the litigation is most prevalent is typically where the money is. And the leading financial centers are frequent visitors into the judgment enforcement world. New York and London have perhaps the most highly developed law on judgment enforcement, creditors' remedies, and the judges there are knowledgeable, sophisticated, and familiar with judgment enforcement. There are a lot of banking centers that attract people who want to keep their money there because there's a sentiment that it's safe. Switzerland has been one of the leaders in that. And then there are a variety of offshore jurisdictions, the Channel Islands, the Caribbean, that are quite popular. And then in Asia, the centers for judgment enforcement are typically Hong Kong and Singapore. And Hong Kong, as a English Crown inherited legal system, is quite similar to the UK system. And what is the hallmark of these places and why they're popular for judgment enforcement? As I said, the courts are familiar with and fluent in judgment enforcement, but they also allow, fairly broad remedies. I mean, one thing I always tell clients when they have a case against a large company that has activities around the world, or an individual who has activities and has probably hidden or secreted assets, that London is a very good place to go. Because in London, there's something called a worldwide freezing order that's available, which seems to many of us, particularly as American trained lawyers, that that seems to be an injunction or an order that goes far beyond the court's power, because these orders purport to freeze assets around the world. It's a little bit of a kind of a hangover from English colonial thought that the crown and the empire carries with it powers around the world. And putting aside the sort of philosophical questions about that, but as a creditor's lawyer, it's a very significant tool. And oftentimes debtors, if they're not familiar with this, say, wow, I have to disclose all my assets around the world, and this order purports to freeze my assets around the world. So that is a very a popular tool that is used. And as I said, New York, because it's a financial center and almost every bank in the world has a branch there, and the courts have a number of tools at their disposal. In the federal courts, through the federal rules of civil procedure, state law is largely what's used to enforce judgments. And the federal courts in New York, unlike a number of other jurisdictions, are quite familiar with that process as they do it frequently. So you have, like in New York, you have something called a turnover order, which is generally directed against third parties and is really a sort of derives from ancient equitable doctrines that orders a third party who has assets in the possession of the debtor to actually turn them over and bring them to the jurisdiction for execution of the judgment. So those are sort of some of the highlights on how and why judgment enforcement tools are implemented.
So let's build on just on that concept that you mentioned at the end with third parties. From a financial services industry perspective, I would imagine financial services companies certainly are debtors and creditors, but also get brought in as custodians or holders of assets. Can you speak a little bit to the unique application of this issue to the financial services space?
Sure, and I think for those of you who work at financial services, who are maybe interested in representing them, it's very important to understand what Matt just mentioned, because almost any judgment enforcement case of any consequence will involve financial institutions, typically as someone who's holding assets of the debtor. Now, let's take New York. New York has an interesting perspective on judgment enforcement vis-a-vis financial institutions, because as I mentioned before, it's a popular spot and one that is favorable in many ways to creditors, but it's also, the financial services center of the world, and that it is not unmindful of that role as well. So there are a lot of statutes that are protective of financial institutions, and judge-made law that is also protective of financial institutions. Perhaps the most critical example of this is called the separate entity doctrine. There has always been a dispute in the law and vigorous litigation over if Bank A has a branch, let's say in New York, but is headquartered elsewhere, or the assets that are being sought are located elsewhere, let's say in Switzerland or England. If you have jurisdiction over that bank in New York, do you have the power through a turnover order or otherwise to order that bank to bring that money from a foreign branch of the same bank to New York? Historically, the answer to that question was no, and it was often because they were separately incorporated, or that through the absence of technology, it wasn't easy to do that. Now those issues have sort of gone by the wayside, because typically most banks are a single financial institution. But New York has recently, through a decision from the New York Court of Appeals of a couple of years ago, reaffirmed, even in modern times, the separate entity doctrine, such that in my example, the bank who's present in New York, but the funds are located in Zurich or in London or Frankfurt, is not required to bring those assets to New York. Now, for a creditor, that's not the end of the road. What that means is that you have to go to where the assets are located, take your judgment, have it recognized abroad in the locale of the financial institution that's holding the funds, and seek it to be recognized, which, as an aside, from United States has no treaties on judgment enforcement, unlike Europe and other geographic locations. So you have to actually start a new proceeding in Europe, have your judgment recognized, which typically happens, though there are exceptions to recognition of an American judgment, like punitive damages are not typically recognized. If there wasn't real jurisdiction over the defendant, you could seek to have the judgment not recognized, or whether the judgment is an affront to the public policy of the country where you're seeking to have it enforced, like that cause of action isn't recognized in the country. But in any event, so you go to that foreign country, have your judgment recognized, and then seek to have the assets attached. And along the way, before that happens, perhaps one of the most important things to maybe leave you with is that always be mindful of pre-judgment remedies. Is it possible to attach funds before you have your judgment finalized? It's not possible to do that against sovereigns, because under most law, including that of the United States, sovereigns are exempt from pre-judgment attachment. And much of the case law and developments of late involves cases against sovereigns, like the Venezuelan bond default and things like that. But in a typical private commercial case, there are opportunities to get pre-judgment attachment so that you can freeze those assets before your judgment. Because as I said at the beginning, always be mindful of how you turn the piece of paper into money. And from the beginning of your case, if you think you have a recalcitrant defendant that's going to not pay voluntarily, seek a prejudgment attachment if the law allows for it early on in the case.
Steve, that was great. Thank you for kind of bringing us back to the beginning with your final comments.
All right, well, great. And if there's anything we can do to be of assistance, as I said, we've been doing this for a long time, and we think we could be helpful to anyone who has difficult judgment enforcement issues. Thanks so much. It's been nice to be with you, Matt.
Thanks, Steve. And that does it for another episode of Steptoe's Financial Services University, where today we talked about judgment enforcement. Of course, you can watch more of our Financial Services University videos and learn more about our financial services practice at steptoe.com. Thanks for watching. We'll see you next time.